हाय दोस्तों, ब्रास ग्रुप के चैनल में आप सभी का स्वागत है। ब्रास ग्रुप आपके लिए लाया एक नया लेसन। आशा करता हूँ आप लोगों को पसंद आएगा। धन्यवाद।
I have time to continue in that kind of detailed manner, case after case, because we have some 50 cases. We just don't have the luxury of time. But I did that because I wanted to indicate to you that that it would be a little difficult if we were to, but the kind of detail that I expect you when you read a case, when I say read a case closely, it means you would be looking at that. Now let's just quickly revise the main points in that state of West Bengal versus Union of India. Now if you look at the majority judgment, which was actually by Chief Justice Sinha for himself and for other people, you will notice that he makes this wonderful line, which is actually perhaps the most important line in that judgment, and which has been repeatedly used in other judgments and in textbook writers also. He says the legal theory on which the Constitution was based was the withdrawal or resumption of all powers of sovereignty into the people of this country, and the distribution of these powers, save those withheld from the union and the states, between the union and the states. So the constitutional fiction, when we begin the constitution by saying, we the people of India, all the powers that the British Crown had were resumed again by the people. And we've already in earlier classes noted the distinction between 395, which negates the Indian Independence Act, the consequences of that, the constitutional consequences of that, is the reversion or the resumption of all sovereignty in the people. And that's something that the judgment of legal sovereignty, that legally where does sovereignty rest? It rests amongst the people. I want to make 2 points here. One, I'd like you to go back to what you studied in first year about the Austinian sovereign. And the Austinian sovereign fitted in a schema where we were dealing with a monarchy, with an individual, habitual obedience, undivided sovereignty. But the moment you have a democracy, you know that the Austinian sovereign doesn't quite work. Because even if the people are the legal sovereignty, this judgment makes the point that political sovereignty rests with the Parliament of India. So sovereignty itself has gotten split at this point in time between legal sovereignty and political sovereignty. That's one deviation from the Austinian notion of sovereignty. And if we can think about this, and I'm happy to discuss this further if there are questions. But straight away you see that. Number two, that when the transfer of power took place from Britain to India, by virtue of the preamble foregrounding the start of the Constitution and Article 395 bringing up at the rear, what you find is that there is a resumption, and therefore Chief Justice Sinha can clearly say the legal theory on which the Constitution is based was the withdrawal or resumption of all powers of sovereignty into the people. So it was not a transition as is popularly seen as from the British rule to the Constituent Assembly and thence on to the Constitution. It's actually that there is a diversion back to the people and then from the back to the people back to this. And that's a very critical structure of the argument of Chief Justice Sinha's judgment. And you can readily see the different political principles that you can withdraw from this. That there has been a lot of literature on what is known as colonial continuity. That there was no break, the brown Sabs took over from white Sabs. Either that's kind of a rhetoric, that kind of strand, or if you read, so I think the first person to talk about this was actually Professor Bakshi. Okay, but I see that later on younger people have written about this more. There is this short story by Sadat Hassan Manto called Naya Kanun. And he talks about the 1935 Government of India Act. And he says that there's so much expectation, but the old law was completely, the 1919 became the 1935. Please read it if you have time. Naya Kanun is the name of the short story. Now, that colonial continuity argument that actually that there was a clear transition of power is not the real legal way in which the Supreme Court is tracing it. So then it goes through a triangle. It goes to the people and then from the people back. Otherwise, the preamble is completely a mere flourish, as Mr. Sirvai put it. But if you want to give it content, you have to have this theory. That's first. Number two, I talked about the legal and political sovereignty. Then the court examines whether sovereignty vested in British India, whether sovereignty vested in the princely states. And those of you who have read the judgment closely, and I hope you read your notes, you will notice that the judgment says that I'll come to Government of India Act in a moment, but they say that with the doctrine of lapse, once the 562 princely states, even they, when they became part of British India, they gave over the most critical powers to the British Crown. And which were those critical powers? The powers of defense, the power of not necessarily minting money, that took a little bit of time, but power of defense definitely handed over. Therefore, the judgment says that when each one of those 562 states signed merger agreements with the Union of India, if you look between the period 1947 till 1949, there were merger agreements after merger agreements signed. 562 princely states. Today, politically, the issues of the merger agreements that are still being discussed are, of course, most famously the Kashmir. Maharaja Hari Singh and his merger with the Government of India, the Constitution of India, in October 1949. But there was also the Nizam of Hyderabad. That's another 49. And earlier there was Manipur and Nagaland. These four continue to be in the news for various reasons because of those merger agreements that took place. Now, what happened when the merger agreements took place? And those of you who have read the judgment, which paragraph am I talking about? Anybody? Merger
I'm 25.
25, okay. Would you like to read out what you think I'm talking about?
There were Indian states which were in the sense sovereign, but their sovereignty was extinguished by various merger agreements, which the rulers of those states entered into with the Government of India before the Constitution. By the virtue of another line.
Yeah.
By the virtue of the process of integration of various states, they emerged a centralized form of administration. In the Governor General, who was the fountainhead of the executive authority.
Thank you. That was good, Akansha, because what does it say? I'm reading the first phrase. There were Indian states which were in a sense sovereign. They were still not fully sovereign, in a sense sovereign. Now, some states had never become part of British India. And I think perhaps Nagaland had never ever been a part. It had stood outside even in the Northeast Frontier Agency. Okay? But others had sort of agreements with British India. The Indian Independence Act of 1947, enacted by British Parliament, gave a choice. It said the whole of British India will be divided between India and Pakistan. What will be the way it will be divided? When we come to Berubari Union, but the appointed day, which was 3rd of June, Mountbatten said that the borders are going to be drawn. And the borders were drawn. And they were notified in June. And then began the big the biggest migration perhaps the world has ever seen. It was bigger than any other migration of anywhere in the world, where 6 million people crossed in a matter of just a month. And the train to Pakistan captures that migration beautifully. Now, but when it came to the 562 Indian princely states, they were given a choice. And what was the choice? A three-way choice. Either go join India, either join Pakistan, or remain independent. And the state that took the longest to take up its mind and decide whether to join India or Pakistan was actually Hyderabad. Okay? Hyderabad was actually wondering what it must do. But there were, so as I mentioned, the four that continued for a long period to raise legal issues were Nagaland, Manipur, Hyderabad, and Kashmir. All the princely states, Junagadh also, I agree. Junagadh also, and you know that Junagadh has been in the news because of, Hindu population, Muslim king. That issue has been there. Now, so once they signed the merger agreement, sovereignty passed directly, as this paragraph shows us. Now, the argument of the majority is to show us that even in British times, the sovereignty vested with the. So, though there were provinces, the dominion of India, which exercised. And post 1950, the inheritor of that sovereignty was the Union government. Was the main argument that you see here. Now, sovereignty is a principle that is better examined under international law. So you normally look at the principle of sovereignty when you are looking at other states. So if you look at the history of international law, I think in one sense the Treaty of Westphalia of 1648, the old Treaty of Westphalia, marks a shift in international law to a rule-based principle where each member state is seen as worthy of dignity, big or small, and that the interrelation between each will be based on principles. So even as a principle, say like Pacta sunt servanda, is actually acknowledging the status and sovereignty of an individual state. And what you find here is, just give me one moment, I'm seeing some chats of, some distortion from my side. Okay, can you all hear me?
Yes, ma'am. Now it's fine. Now it's fine.
Now it's fine.
Ma'am.
Yeah, I'm. I had some problem yesterday. Students from my section couldn't enter the class. So at some point, if I have a difficulty, I'm going to have to take some steps. Okay. Where was I? Yeah, first of all, international law and the idea of sovereignty. So it looks at another except through a rule-based system of international law, then you are sovereign. But there is another political sovereignty that this judgment is talking about, which is vis-a-vis the people who are sovereign. And in that sense, the ability of an entity to determine the rights and liability of the subject is determinative of sovereignty. And what this judgment very clearly tells you is that in India, after the constitution, sovereignty is exercised not by the state governments, but by only the union government in that sense, because it has overriding powers to operate over the people. Now, in order to establish that, you will see that they have to deviate from the definition of the federal principle or of a pure federation laid down by K.C. Ware. And K.C. Ware says your ability to operate directly on the people, both through the central government and through the state government, independently and in a coordinate fashion, is determinative of the federal principle and is determinative of a federation. That is, two governments operate independently and coordinate of each other. And this entire judgment is full of examples to show you that in ever so many ways, the central government and the state governments are not on par. There is a privileging of the center. In legislative matters, I'm not going to run through all of them. You are all adult and I think you are capable of reading. In legislative matters, there is a capacity to override which central parliament has in ever so many ways over state legislatures. So though there is a separate state list and though there is a central list which sets up a position as if they are completely independent and autonomous of each other, in practice it's not there because the power to override has been given. Rajya Sabha with consent for international treaties in times of emergency, so on and so forth. Legislative power. The definition of the federal principle by Casey Ware says operate directly on the people, and that operate directly is a signal to tell you that it's dealing both with legislative power and the executive power. And once again, there are another set of examples that the judgment vividly puts out where executive power also is clearly the upper hand is held by the central executive. Example, Articles 256 and 257. Every state government has to conduct its government in order to implement the laws made by Parliament. They cannot cutely turn around and say, that's your law, so you implement it. No. Every state government is under the duty to implement a central law. And refusal or intransigence in implementing a central law can allow under Article 365 for the president to draw a conclusion that the affairs of that state are not being conducted in accordance with the provisions of the Constitution. And under 356 to issue president's rule, take over the government. Okay? So you can issue directions, you have to implement the state laws. And of course, and as I'll just come to an objection, in fact, that the DMK government made during the Sarkaria Commission, that the All India services are at the disposal. So when you join the IAS, you are made and allotted a state cadre. But disciplinary powers continue to be with the DOPT at the center. So you are, for all intents and purposes, under the employment of the central government. Your services have been, as it were, parked and you are made part of a state cadre. So in ever so many ways, the upper hand in executive matters is also with the central authority. Thirdly, it says there are no separate constitutions which are usually there. Fourthly, that there is a central unified judiciary. And very, very importantly, it says to be a true federation, previously independent and sovereign states come together in equal terms to put together a federation. If you take the erstwhile USSR, Union of Soviet Socialist Republics, there were all these different Soviets, Uzbekistan, Azerbaijan, Tajikistan, Moldavia, Latvia, so on and so forth. All of them coming together in the 1936 Soviet Constitution. Earlier independent, now coming together. Okay. We call it Russian Revolution because the largest revolution, Soviet, was of Russia, the RSFSR. Okay. That was the biggest republic, but the other republics were also there. And in fact, interestingly enough, if I can just tell you at a tangent, even after the USSR came, Ukraine continued to have independent member country status in the United Nations. They never merged themselves in terms of international law, and that created complications and a very nice, curious situation. Just like India, which was under British rule, but in the League of Nations, at the end of First World War, India was a separate, independent member in the League of Nations. And this also caused a lot of problems in international law. Okay? If you look at, whether the permanent PCIJ, for example, what was the status of India and its membership? And, well-known minds like Lord Park, etc., wrote about this matter, whether it's even possible. But we don't have time to go into that. I'm just flagging it in case any of you is interested in reading more. Now, therefore, what you find is that in legislative terms, in terms of executive, etc., that we are not a federation because they are not sovereign. States are not sovereign. Sovereign states did not come together. They are not independent and separate because the center has this huge capacity to override in ever so many ways. And therefore, Chief Justice Sinha can say that India is not a federation. If India is not a federation, then entry 52 of the 7th schedule, under which that coal-bearing act was enacted, entry 52. And I'm going to read entry 52. Please look at entry 52, 7th schedule. It will really help if you have a copy of the Constitution handy, because those of you who are listening to this on the phone, I don't quite know how you will. Okay. Industries in the control of which by the Union is declared by Parliament by law to be expedient in the public interest. And a declaration was made in that Coal-Bearing Acquisition Act that it was in public interest that India would, the Union Parliament and the Union government would gain control of these unworked mines that had not been leased by the state governments. And therefore, the court establishes that there is no sovereignty in the states. If you read the case a little more in detail, you will find that though there is no sovereignty in the states, because it was resources that were owned by the states, sometimes there used to be a thing of giving royalty back to the state because those states' main sources of income used to be timber, it used to be coal, etc. So even today there is a small amount of royalty that goes back, though the ownership is clearly in the hands now of the Union government. So let me just pick up the coal story a bit before I come back to the federalism story once again. And I had asked you, what is the legal framework under which coal mines are controlled in India today? Yes, those who did that work which I'd asked you to read. Which is the law which governs coal mines, coal licensing after the 2G judgment of the Supreme Court, where all coal licenses were cancelled and they were then auctioned. The mines continue to belong to Union Parliament. We only allow the working of the mines to be leased out. So there are coal lease mines, which is the law which controls coal in India today. Anybody? Coal Mine Special Provision Act and the current amendment of 2020 just before the lockdown, what did it do?
It allowed private sector to participate in export.
And it did another more important thing. It allowed also foreign players to now be eligible for bidding. Okay? So I'm not very sure. It's as part of an industry. I'm not following it too much, but I think there's no reason why the largest players, like the big coal players, would not also be allowed. Now let's come back to the federalism story once again. So for these reasons, no sovereignty in the state, override given to the center, and therefore, what does the court say? And I want to read out 2 paragraphs. I'm reading on paragraph 23, please. If you have it open, please look at it. All these arguments, which summarizes all the state of West Bengal arguments, except the purely interpretational, are ultimately founded upon the plea that the states have within their allotted field full attributes of sovereignty and exercise of authority by the union agency, legislative or executive, which trenches upon that sovereignty is void. And then What the court in response says is somewhere in paragraph 36, what appears to militate against the theory regarding the sovereignty of states is the wide power which Parliament is invested with to alter the boundary of states and even extinguish a state. So the foremost power that takes away the sovereignty of the state is actually the territorial question, not the legislative or the executive override powers. Okay, so I'm wanting to point this out to you because according to Chief Justice Sinha, the factor that most militates against sovereignty is the territorial question. That there is no territorial integrity of states under the Indian Constitution. And in just 4-5 minutes, I'm going to go into that. But that it says is the foremost, and then he talks about legislative and executive powers. So the rest of the judgment deals with those executive powers. And he says, concluding therefore in paragraph 46, he says that the constitution which makes the division of legislative and executive powers between the union and the states is not founded upon such a postulate. That is the postulate of two kinds of sovereignty. Two kinds meaning central and state sovereignty. I'm not now talking of political and legal sovereignty, which I've already discussed. And the concept of superiority of the union over the states in the manifold aspects already negatives the idea of any presumption of state-level sovereignty. And therefore, that ends that argument. And to buttress that argument, so look at the way the argumentation in the judgment flows. They first pick up the provisions of our present constitution and look at it. And then by way of addition, then he goes on to Government of India Act 1935. See the structure when you write also. It's not all over the place. He picks up the constitutional provisions. He says territorial integrity is lacking for the state. No sovereignty in the state. Example, legislative, executive, citizenship, judiciary. Then he comes to Government of India Act. Now, what is the argument that Chief Justice Sinha takes with regard to Government of India Act to once again say that there is no sovereignty in the states? Anybody? Yeah, anybody? What's the argument that is based on Government of India Act 1935? Who would like to speak?
That Indian states never joined the proposed federation. They were supposed to join it.
That's true. That is, right from 1858 till 1935, there was only one central power, Governor General and Council, which transferred to the central legislative authority under the control of the British Parliament. They were provinces, but they only had devolution of powers. It was still a diarchy system. Some were reserved, some were transferred. In 1935, possibility of creating a federation with central legislative assemblies and provincial legislative assemblies was thought of. But that part of the 1935 Government of India Act never came into force because before it could come into force, it had to be ratified by more than half the number of provinces, etc. And by that time, World War II broke out. British India dragged India into the Second World War, and as a protest, all the provincial governments led by the Congress resigned, and that was the end of the Government of India Act. And therefore, they made the point that even in 1935, it was only a central power. There was still no federal power in existence in India, and therefore, what got transferred was the sovereignty that got transferred through the people back to the Union Constitution of India. And what about Article 294 and 298, which say that the states, the property in the British states will now stand transferred? That is only a limited right of property, commercial rights. The principle of sovereignty, that you have untrammeled powers without anybody's interference, that did not exist in the states. That's the argument. And then the judgment uses these words, escheat, lapse, and bona vacantia. I'm going to spend just a minute on that. I'd like somebody to just explain to me what is escheat, because now I'm coming to property rights. Escheat and bona vacantia. Yes. What's escheat? You've studied this. Which law did you study the escheat in?
Family law.
Yes, Hindu Succession Act. So please tell me what is escheat. Yeah, Mansi, you said.
When no one is the owner, then government is the owner of that property. The title transfers to the government.
So the principle is that private property cannot have a vacuum. It must be owned by somebody. So if there is no class 1 heir and there is no class 2 heir and there has been no testamentary disposition of property, if we say the family line yahan pe khatam ho jata hai, the property will actually pass to the government. That's the principle of escheat. The principle of bona vacantia is that if there is property and there is no owner, then the government will step into that gap. Notice the difference between escheat and bona vacantia. I've told you the meaning of these two. We've discussed the meaning of these two. Now tell me the difference between escheat and bona vacantia. In escheat, there was an owner, but there's no testamentary or intestate heir available. The property goes to the owner, to the government. In bona vacantia, there had never ever been a private owner. It was unowned, unclaimed property. That bona vacantia will always come up into the hands of the government. So let me just take a very silly example. Suppose there's an earthquake and a new island gets thrown up in the Bay of Bengal. It's a property, but a property which had no owner ever historically in it. It's a bona vacantia. You will just go in and it will automatically become government property. We won't use the word escheat because it will never belong to anybody. We will use the word bona vacantia. And then there is a last word which I'm going to use, not used here, eminent domain. Does anybody know what this word means?
Yes, ma'am.
Tell
Ma'am, eminent domain is the power of the government to take private property for public purpose.
Very good. So here is another way to acquire property. One is by escheat, second is by bona vacantia, third is by eminent domain. And because one of the attributes of sovereignty is the power to take over any other property belonging to anybody else. That's eminent domain. But we are not using the word eminent domain here because it's not private property, it's actually state property. And to justify that, they talk about the entry 52, whereby a declaration that is in the national interest, Parliament would make that 1957 Act. And therefore, it is exercising a right given to it. There is a very weak argument put up by West Bengal that in Government of India Act 1935, an express provision under Section 117 had been placed that you can take over this property. But that was not there in this constitution. The court says just because there's no express provision in the black and white in the constitution, it doesn't mean that the Union Parliament does not have that power, because entry 52 allows Union Parliament to make a law to take over an industry by a declaration made in the law for the purpose that is for national interest, and that is fulfilled by the 1957 Act. Therefore. Now, I have gone in great detail in these aspects of the judgment to tell you that the more closely you read it, the many more times you read it, a reward will always be there for your understanding. Because there are so many aspects that you will find here. For example, did it matter whether this had been acquired before the Constitution, after the Constitution? And you will notice how carefully the judge has crafted his words. Just for example, look at paragraph 60. So I think a lot to do with the judge and a lot to do with the lawyer and those of us who are studying law is the choice of words. Okay? There is a rich vocabulary and you are better off if you can choose the precise word for explaining. Look at paragraph 60, for example. The court says it would therefore be manifest that the right of the centre to require the province to part, meaning give away the property, for the effective performance of central functions was not considered as detracting from provincial autonomy. They've used the word autonomy, they have not used the word sovereignty. Okay? So they've chosen their words carefully. Now, when it comes to the dissenting judgment of Justice Subbarao that we were talking about, terra nullius is also there. Terra nullius, where there has never been ownership over that, yes, and I agree with you. The thing is that terra nullius is actually outside of your borders, okay? But bona vacantia would be within your borders, and that's the reason why I said Bay of Bengal, okay? Because it's within the territorial borders that the island would have come. Terra nullius is outside your borders, okay? Yes. What was the argument that Justice Subbarao put? Now, Justice Subbarao, and here I have to tell you that I'm referring to an article by Professor P.K. Tripathi. You remember that I mentioned that Professor Tripathi was the Dean of the Law Faculty, and he was also a member of the Law Commission and one of the best-known constitutional lawyers, and he taught in law faculty just like Professor M.P. Singh, who is also a very well-known constitutional authority, as well as Professor Bakshi. I think the three of them were perhaps the best-known names that we have had, together with also a fourth name that I'd like to add is Professor Parmanand Singh. So I think that was a wonderful period where all of them were teaching here, and all of them have been my teachers, and I'm very proud of the fact that I was taught by them. And when we look at the minority judgment, so Professor Tripathi had written an article years and years ago. So he was commenting on the dissenting judgment of Justice Subbarao. So he says that Justice Subbarao wanted to establish that India is a federation. And the way he did it was, and this is his critique of Justice Subbarao's dissenting opinion, he says the way he did it was by changing the definition of federation itself and changing K.C. Ware's federal principle. Where K.C. Ware had said, in order to be a federation, the two center and state governments must operate directly and must be independent and coordinate with each other, he first tampered with that definition and it said it's sufficient if it is by and large independent. And having once brought down that threshold in order to be a federation, he said, well, then India is a federation. And if India is a federation, then the state and central government both must be sovereign, and therefore West Bengal has sovereignty rights. So that's the way in which the dissenting judgment operates. Okay, I've just sort of summarized it in just like half a minute. But what you can see is that I think Professor Tripathi's critique, according to me, is the best that I've read thus far, is by saying that by changing the goalpost, then he could declare that India is a federation, but be that as it may, it was a quasi-federal. And then, of course, there are all those other words. Now, I concluded that point by telling you that even though that there is a central list and a state list, it appears as if they do not have overlapping powers. If there is overlapping powers, does it take away from a federation? My answer would be no. Just because there's a concurrent list, India has a concurrent list, Canada has a concurrent list, by the way. Okay. And a very, very limited way. There is no express concurrent list in the American Constitution. It only has Article 1, Section 8 enumerates the powers of the Congress, and then everything else which is not enumerated in Article 1, Section 8 is virtually that of the state or that of the people. So that's an example of a single list constitution. Then you have Canada, which has a double list like Australia, and then of course we have India, which has 3 with residuary powers. And the court also points out, for example, that if you look at the 1935 Act, that ill-fated federation which never came into being, but had it come into being, residual power would have been with the states. But when it comes to our constitution, residuary power is with the center. So now there's a good enough place for me to now move on to what I want to begin, which is the next unit, which is Articles 1, 2, 3, and 4, State, Union, and the State Territories. I pointed out to you that Chief Justice Sinha says the lack of territorial integrity of states is a clear indication of the lack of that India is not a true federal country. And before I come to 1, 2, 3 and 4, this aspect has been studied time and again. In 1984, the government of India appointed Justice Sarkaria Commission, known popularly as the Sarkaria Commission, came out with its report in 1987. It's available on the net. And you will notice at that time, the real trigger for the Sarkaria Commission was the Akali agitation on the one hand in Punjab, which wanted, for example, deletion of the explanation in Article 25 of the Constitution. It wanted redrawing of the water sharing arrangements with the Satluj. Why should a non-riparian state like Rajasthan get Satluj water? That had been in demand, okay? As well as from deep south, there had also been demands from the Dravida Munnetra Kazhagam Party about redrawing the understanding of federalism. And the Sarkaria Commission gave a wonderful, one of the best reports on center-state relations that you can read. And it examined the anti-federal features of the Constitution. That's what they called it. I'm not calling it. Anti-federal features of the Constitution and how it can be modified a little more back in favor of states. After that, we have in 2000, Justice M.N. Venkatachalaya Commission. The commission to review the working of the Constitution, in which a sizable part of the Commission's report dealt once again with the center-state relations. Then in the late 2008 or 7, Justice M.N. Punchi Commission. So you have all these commissions re-examining center-state, and where one of the units that we will study, I think Unit 8 or Unit 9, is the question of GST and the entry tax, which is right currently now one of the hottest issues to discuss on the federal. This entire semester is mainly dealing with federalism, mainly in center-state. Okay? So it is a very important issue. And therefore, now I'm going to take up the question of center and states and whether there is any territorial integrity of states. If not, why not? What is the extent of sovereignty and the center? Yeah, which is the article by Professor P.K. Tripathi. Just one moment. Is it there on JSTOR? Somebody has just written. It's called Indian Federalism, the Reality and the Myth. And it's in Journal of the Bar Council of India. Okay. Yeah, that's right. Okay.
Excuse me.
Some Shahbaz has already typed it in the comments. Thank you, Shahbaz. Now let's take up 1, 2, 3 and 4. Yes, please.
Ma'am, just 10 minutes is left and we have a class at 11:30.
Yeah, I'll take another 3-4 minutes and then.
Okay, ma'am.
How did 1 hour run away so fast? Okay, now look at Article 1, Subclause 1. India, that is Bharat, is a union of states, right? And we talked about what exactly happened in our Constituent Assembly. And when you read Professor Tripathi's article, he goes into detail about the Union Powers Committee and whether the residuary powers should be here or there. So you can look at it, but even if you don't look at it, we've discussed it. Now look at Article 1, Subclause 2. Priyasha, just tell me again another 4 minutes, yeah? The states and the territories thereof shall be as specified in the first schedule. So the territorial delineation of India as a country as well as states. Now look at the way the first schedule is structured. It talks about the states, then it talks about the union territories. I want to make one point here. Any property in India, any piece of territory in India has to figure in the first schedule. And the first schedule has only 2 components, the states and the union territories. Therefore, what conclusion can you draw from this? Anybody? What conclusions do you draw?
On the union of these states. They are part of union.
Ma'am, anything apart from the states or the union territory is not
Part of the territory of India. So the moment you find a piece of territory of India, like that little island that grew up outside the coast of in the West Bengal, let's say, has to immediately become part of a union territory or part of a state. There is no Trishanku, a third category ऐसे ही बीच में लटक नहीं सकता. Because why do I say that? My conjoint reading of Article 1, Subclause 2, read with first schedule. The states and the territories thereof shall be as the first schedule. And then the territory of India shall comprise the territory of the states, the territory of the union territories, and such other territories as may be acquired. So there will always be a brief period when you acquire a territory, but subsequently it will either belong to a state or a union territory. Why do I say that? Because under Article 1(3)(c), you can acquire a property. But when you look at the first schedule, it seems to have only two compartments in it, called the states or called the union territories. Okay. So after a period of time, it will get merged either with a state or with a union territory. And therefore, Article 1, Subclause 3, Subclause C tells us any other territory as may be acquired. So at that point in time, there's a listing of states, there's a listing of union territories, but the possibility for acquisition is kept open. And that acquisition of that property has to belong to the Union of India. Now that's something that I want us to examine, because that brings us to the question of our borders. Okay. Is it possible for India to acquire a piece of property in Antarctica? In which case, how can it be merged with a state or a union territory? Because there's no principle of contiguity. What do we do with it? That's one. So is my assertion that it must belong to either a state or a union territory, is it correct or not? What happens when Indian government buys a property, let's say Gandhiji's house or Dr. Ambedkar where he stayed in Harvard and studied? We just buy it. It becomes government of India property. Every high commission. Who owns it? Is it part of a territory of India, or have we just bought that property without it become part of it? So there are many interesting questions. Now, I'm going to continue tomorrow, but what I need you to do is you must spend a lot of time today and begin reading Berubari, because I'm going to take up the partition between India and Pakistan, as well as the recent Bangladesh-India Accord and the 215th or whatever, I'm forgetting the number of that amendment, which has dealt with the merger of territories between India and Bangladesh. Okay. So please read it, and now I am going on. I have time to continue in that kind of detailed manner, case after case, because we have some 50 cases. We just don't have the luxury of time. But I did that because I wanted to indicate to you that that it would be a little difficult if we were to, but the kind of detail that I expect you when you read a case, when we say read a case closely, it means you would be looking at that. Now let's just quickly revise the main points in that state of West Bengal versus Union of India. Now if you look at the majority judgment, which was actually by Chief Justice Sinha for himself and for other people, you will notice that he makes this wonderful line, which is actually perhaps the most important line in that judgment, and which has been repeatedly used in other judgments and in textbook writers also. He says the legal theory on which the Constitution was based was the withdrawal or resumption of all powers of sovereignty into the people of this country, and the distribution of these powers, save those withheld from the union and the states, between the union and the states. So the constitutional fiction, when we begin the
दोस्तों, ब्रास ग्रुप आशा करता है कि आप सभी लोगों को ये लेसन पसंद आया होगा। आप अपना फीडबैक कमेंट बॉक्स में देना न भूलें। थैंक्स फॉर वॉचिंग।